All rise. Oh yay, oh yay, oh yay. All those having business before this honorable court draw near and they shall be heard. The honorable judges, Basanta, Binduan, and Upchurch, with Chief Justice Binduan presiding. God save the United States and this honorable court. Please be seated.
Good afternoon. So it is docket 24-9176. In the Supreme Court of the United States, Minology Incorporated versus Petitioner versus United States ex-rel Riley Ortega, respondent. Again, docket number 24-9176. May I have the petition, please?
Yes, Your Honor. Your Honor, and may it please the court. My name is Michael Cooper, and I, along with my co-counsel Savannah Wallace, represent the petitioner Methodology. Mr. Chief Justice, at this time, I would like to reserve 2 minutes for rebuttal. Thank you, Your Honor. Your Honors, this case comes on grant of writ of certiorari of the 17th Circuit, who affirmed the denial of petitioner's motion to dismiss. We ask that you reverse and grant that motion for 2 reasons. First, because Transylvania's immunity scheme is preempted by federal law. And second, because a fraud on the FDA theory is an insufficient basis to support a key TAM suit under the False Claims Act. I will be addressing the first issue, while my co-counsel will be addressing the second. This court should hold the Transylvania scheme is preempted by federal law for 3 reasons. First, because the compliance provision in subsection A improperly invades the discretion of the Food and Drug Administration. Second, because the misleading the FDA provision is of the same source and vintage of the provision this court struck down in Buckner. And finally, because the failure to warn provision is violative of section 337A of the Food, Drug, and Cosmetic Act. That said, we'll begin with subsection A. Prior to starting, this court must remind itself of the proper preemption analysis, which is grounded in the supremacy clause found in Article 6, Clause 2 of the Constitution, which states that the laws of the United States shall be the supreme law of the land, all laws of the states notwithstanding. This is the bedrock of preemption. To determine whether or not a state law is preempted, this court looks for 2 sources of congressional intent. First is express preemption, and second is implied preemption, where the court determines, based upon either the structure of the regulatory regime or the way in which it is frustrated, that Congress would have deemed state laws preempted. As this court stated in Freightliner v. Merrick, the fact that there is express preemption does not foreclose the importance of implied preemption. There are 2 express preemption clauses inside the Food, Drug, and Cosmetic Act. First,
Does this case involve express preemption?
it does with respect to subsection C. Subsections A and B will be deemed preempted under implied preemption theories. Express preemption first bars under section 337A any form of private right of enforcement. Subsection 337 states that all suits to enforce the FDCA shall be by and in the name of the United States. Section 360K forbids states from imposing any duty that is in addition to or in excess of the duties required under the Food, Drug, and Cosmetic Act. This is also known as the parallel duties requirement, which undergirded this court's opinion in Regal. However, express preemption is not the only way in which things are deemed preempted. And as this court will note when addressing subsection A, they will also be deemed preempted when they frustrate federal objectives.
But there is a presumption against preemption.
Yes, Your Honor. And as this court stated in Rice, when the state is operating within its core police powers, it is entitled to a presumption against preemption. However, there's a couple wrinkles to this. First is that in Rice, the court did deem that a state was operating within its core police powers, but still struck down all 9 state laws as preempted because, as the court stated in Rice, where a state asserts a right to regulate and the federal government also is regulating, though the federal government scheme may be less pervasive, the state's scheme must still fall away. And it was under that test that the Rice court struck down all of the state laws at issue. Fundamentally, because the presumption of preemption may exist doctrinally, but it is not strong and it is easily overcome.
Have you ever held that it's not strong?
Have you ever held this?
Has this court ever said there's a presumption, but it's not as strong?
It's more demonstrative of the way in which the court has actually animated its jurisprudence around the presumption against preemption. For example, in Rice, where it created the presumption, it did not, in any stretch of the imagination, require a great deal of showing of congressional intent. There, the fact that the Secretary of Agriculture had some form of licensing requirement was enough to displace all forms of state regulation of agricultural warehouses, for example.
So it's your position here that state tort law just goes by the by, right? Goes by, should be disregarded in this case. It's preempted.
No, Justice Basanta. As this court stated in Medtronic v. Lohr in 1996, nothing about the FDCA precludes states from having common law tort duties. However, where either those tort duties stand in excess of the FDCA, as this court noted in Regal, or where those tort duties put an extraneous pull on the regulatory scheme, as this court said in Buckman, then they become preempted. For instance, with respect to subsection A, as the Sixth Circuit analyzed in March, when incorporating a standard of compliance by the FDA, but not permitting the FDA to make those compliance decisions, courts meddle in an incredibly discretionary function. And furthermore, they are serving to police an inherently federal relationship. And the court can come to this analysis without relying on circuit precedent either. Fundamentally, because looking to section 355D of Title 21 of the US Code, it is important to remember the way the FDA makes approval and compliance decisions, which is by consistently weighing the risks to the affected population while also looking to the potential health benefits of innovative devices.
How would permitting this claim actually cause an interruption of the regulatory powers of the FDA?
Yes, Your Honor. So a couple of different ways. First is that the Office of Product Evaluation and Quality, which is the office within the FDA that is responsible for making these determinations, reviews more than 22,000 different products annually. And a huge concern that this court has had time and time again, but particularly in Buckman and Regal, is that where states supersede what the FDA is doing, or at times second guess it, it leaves the agency open to cumbersome discovery that their decision makers' time is taken up with, as well as, oh, yes, Your Honor.
How would you describe this as second guessing FDA? I mean, because obviously we still allow state products liability claims to proceed in other things that have also been regulated by the FDA. So how does respondents' claim here actually disrupt the ability to regulate?
Absolutely, Your Honor. So when we are determining whether or not something is compliant with the FDA and a jury is taking that into account, ultimately what the jury is doing is taking what it might deem to be what could be deemed a black letter procedural violation of the FDCA. However, the FDA doesn't always act on those because it balances a number of things. Not only the reasonable assurance of effectiveness and safety, but also the availability and affordability of drugs and devices. And so
the compliance question here actually being raised in the defense by your client and not in the prima facie case of the respondent?
To the extent of subsection A, actually, this is part of the prima facie case, whereas subsection B and subsection C are perhaps treated as affirmative defenses. That said, all three disrupt in similar ways because they lead to a second guessing of the FDA's action or inaction, which is a particular concern of this court's in Regal, where they noted that permitting a jury of 12 to second guess the FDA is particularly problematic because the FDA spends 1,200 hours reviewing a product for pre-market approval and continues to regulate it. However, jurors are confronted with only one troublesome set of facts that are particularly related to sympathetic injuries. However, the court was conscious that permitting hard facts to make bad law undergirds the important principles of the Supremacy Clause. The Sixth Circuit in Marsh, as well as the Ninth Circuit in Neidig v. Perez, both pointed out that permitting courts to enforce compliance provisions without the FDA making similar decisions is the kind of intermeddling that frustrates the regulatory balance of the FDA, and exactly what this court struck down in Rice, in International Paper, and in Gallo v. Honda.
Wouldn't this be more true if the respondents were actually challenging what was approved by the FDA? I mean, isn't the basis of this claim that we're not challenging what was deemed to be compliant or not compliant, but this is just completely different than what you received approval from the FDA?
Your Honor, this is actually a really interesting wrinkle inside Section 814 of the Code of Federal Regulations. And the reality is that changes to a product can be made without notifying the FDA so long as they don't affect the safety and effectiveness of the product. And importantly, the recall of the Philips product that respondent relies on in the subsequent releases as appended in footnote 1 that discuss the different releases of the FDA, note that the silicone that was originally approved caused substantial risk of suffocation and hypoxia. And so the change from silicone to paper foam doesn't necessarily, or at least allegedly, could not have affected the safety and effectiveness because both products were dangerous for different reasons. And this goes to the discretionary function of the Food and Drug Administration, who makes decisions balancing risks and benefits. And that's why subsection C, which requires a plaintiff to demonstrate that the FDA would have made a different decision, so incredibly problematic. Because at its core, it requires a jury or a judge to determine that the FDA, who sat there with 1,200 hours of review, countless amounts of data, as well as balancing risks and benefits of innovative products, as described on page 3 of the record.
You're asking us to, you just told us, well, silicone, polyurethane, it doesn't matter, they're both dangerous. And so ignore the fact that they changed your client changed the product after it was approved. That asks us, in effect, to substitute our judgment for the FDA. It doesn't matter what the FDA says or doesn't say, it doesn't matter. But I'd rather have a jury, a fact finder do that than the three of us sitting up here today say, well, it all doesn't matter. Doesn't FDA approval and then changing the product purposefully to save money after the product has been approved and not telling anybody, doesn't that cause you any problem?
So on the contrary, Justice Basanta, the important thing here is that by pointing out that silicone was dangerous, that release was 8 days before the FDA approved this product. So the point there is that the FDA approved something it knew was dangerous. And so the point is really just that the FDA makes decisions that are sometimes balancing of risks. And we don't know what the FDA would have done. And that's why the Transylvania statute is problematic. Yes, where companies behave poorly, there ought to be consequences. But that doesn't provide an avenue for states to construct preempted statutes. It's the role of the FDA, which this court noted in Buckman, has myriad tools to police not only fraud, but non-compliance. That said, finally, subsection C is also preempted because it's violative of section 337A. As the First Circuit in DeCroce, the Eighth Circuit in Bryant, and the 11th Circuit in Mink all note, though a failure to warn is perhaps not necessarily an a-parallel duty to the FDCA, they are problematic where they are seeking to enforce explicitly the terms of the Food and Drug Administration. Or put differently, the problem with the failure to warn theory enclosed in subsection C is that it is a suit that exists only because of the existence of the FDCA, because its only avenue to relief is demonstrating that someone did not comply with the labeling requirements of the FDCA. In the alternative, this court can also deem that the specific theory by which the respondent is attempting to abrogate immunity on the basis of a failure to warn is also in excess of the FDCA and in violation of section 360A, because the only place The duty to list allergens, as the respondent requests on page 5 of the record, is found in one guidance document by the FDA from 2001. That is not a binding thing on the agency, and it is not included in the statute or in regulation.
And we were to find that the claim is not solely based on only a violation of the FDCA. Would the respondents prevail as to subsection C?
Your Honor, I know my time's almost up. Can I answer briefly and conclude?
Yes, you may.
Thank you, Your Honor. So to the extent that they are imposing a duty in excess of the FDCA, their claim is preempted entirely. That said, this court should hold that these different schemes frustrate the objectives of the FDA and in part are in excess of what is permitted by. Thank you.
May it please the court. Good afternoon, your honors. As previously introduced by my co-counsel, my name is Savannah Wallace. I also represent the petitioner, and I will be addressing the False Claims Act issue. In cases where the FDA is aware of the alleged fraud and chooses not to take action, the fraud on the FDA theory is not a sufficient basis for a relator to bring a key TAM action under the False Claims Act for the following reasons. Not only does the theory fail to satisfy the causation element required for an FCA claim, but the theory also fails to satisfy the demanding materiality standard required to prevail on such a claim. For these reasons, petitioner respectfully requests this court reverse the judgment of the Court of Appeals below and render the motion to dismiss granted. I'd like to begin first by addressing the causation element and specifically how a relator fails to satisfy this element where the FDA chooses not to act. Now, the Court of Appeals relied very heavily and disproportionately on the Escobar case, which came out of the Supreme Court in 2016. Now, in relying so heavily on the Escobar case, the Court of Appeals neglected the importance and necessity of establishing a causal link between the alleged fraud and the subsequent payment decision. And this is something that Justice Rusich talked about in his concurrence on the record at page 40. Now, the Court of Appeals relied so heavily on the Escobar case on the basis that the relator appeared to be relying on an implied false certification theory of liability. Now, their reasoning for which is on the record at page 36. But this point is moot because, as this court stated in Ex Rel Hindau versus the University of Phoenix, regardless of the theory of falsity that a relator brings their claim under, the relator must sufficiently establish all 4 elements of an FCA claim, which are knowledge, falsity, causation, and materiality.
Counselor, shouldn't we remand this for more determination on causation? It seems like since that is truly a question of fact, and this was dismissed as a 12B6 motion to dismiss, that we really don't have the opportunity to evaluate whether or not they prevail on cause.
Well, Your Honor, actually, I'm going to point you to a case out of the First Circuit, United States Ex Rel Narwhal versus DePuy Orthopedics. And in that case, the First Circuit balanced the demanding materiality standard applied in Escobar while still recognizing the missing causal link in cases where the FDA knows of the alleged fraud and chooses not to take action. So to your question, in that case, 2 hip surgeons brought suit against a medical device manufacturer, alleging that the manufacturer made false statements, but for which the device would not have been approved. Now, in that case, the First Circuit ultimately held that because the FDA knew of the alleged fraud and chose not to take action, there was a fundamental break in the causal chain between the alleged fraud and the subsequent payment decision.
So what stage procedurally was the case in the First Circuit?
The court dismissed that claim.
On 12B6?
Yes, Your Honor. And not only that, and the importance of Narwhal is that the Narwhal court applied the demanding materiality standard from Escobar that the Court of Appeals below was so eager to adopt. But unlike the Court of Appeals below in this case, the Narwhal court applied this demanding standard while still balancing the rest of these elements and recognizing the missing causal link in these cases specifically.
What would the, I'm sorry, go ahead.
Just, okay, so CMS won't pay except in very limited circumstances for unapproved medical devices, correct?
Yes, Your Honor.
Okay. So was the device that your client marketed and sold to Ms. Ortega, was it the device that was approved by the FDA?
According to the record, the device was approved with the silicone foams. Now, exactly.
So can you answer my question, yes or no?
Yes, Your Honor. So the device that Ms. Ortega received did not have the silicone foams and had the PEPUR.
So it was not an approved device.
That was not the device that specifically that had the exact silicone foams, obviously, and that's proven on the record.
Right.
But the fundamental point here is that the FDA is responsible for evaluating the safety and efficacy of products, whereas CMS makes its own independent payment decisions. So nothing on the record supports that the FDA would have made a different decision or would not have approved the product without the silicone foams. And this just goes to the fact that the FDA has a very unique regulatory role. And there's layers of separation between FDA approval and the subsequent payment process. And what's so important about that is that because the causation element requires a direct link between the alleged fraud and the payment decision, that means here that the falsity must be proven integral to the claims submitted at both phases.
Counselor, we're not at a point where they're proving things. This is a point of just alleging enough facts to meet the standard by which you can overcome a motion to dismiss. So what would a claimant need to allege in order to meet the standard to dismiss under 12 meeting?
There must be some type of factual indication on the record that shows that the FDA would not have approved the product with the PEPUR foams. And on that point, the respondent relies so heavily on the Philips recall, on the fact that Philips voluntarily recalled that product. And as my co-counsel spoke to the fact that the FDA is still in the process of evaluating these PEPUR foams. So when it comes to these two-step processes where we have FDA approval and then the subsequent request for payment, both the 7th and the 9th circuits have held that the falsity must have been integral at both phases. Now, moving on to the materiality element here in this case. The False Claims Act definition of materiality is very clear. It's section 3729, and it's something that has a tendency of influencing or be capable of influencing the payment or receipt of money. And this court elaborated on the demanding and rigorous nature of that standard in the Escobar decision in 2016. And the Escobar court noted that this rigorous standard for an FCA materiality element is required to prevent the False Claims Act from being used to punish a garden variety of regulatory compliance issues. And that's something that we're seeing here. The respondent has only alleged facts that go towards regulatory fraud and only have to do with the FDA's approval process. Nothing.
What facts would she need to be able to allege in order to meet the standard to get past the motion to dismiss?
We would need something else on the record that shows that a different decision would have been made.
And what would those be? I'm just asking because we would have to provide an opinion to guide lower courts. And you're saying what she has right now is insufficient. What kinds of facts would we need to find, or examples of them, to meet the plausibility standard?
FDA action or government action. And that's the big crux of the argument here, is that if the False Claims Act is meant to police fraud against the government, and the government is faced with this fraud and these allegations and chooses not to take action, in this case, the DOJ has not intervened, which, although it's not dispositive of the case, absolutely goes towards neglecting or negating this materiality element and any allegations that any alleged misrepresentations were material. Because
So you're saying that the fact that Ms. Ortega was, that the government didn't intervene, that creates some doubt in her case. What's your authority for that position?
well, that's just, I would argue, it's logical nexus, Your Honor. And here, but the government, or not the government, the Escobar court noted that materiality can be demonstrated by showing that the government routinely does not pay claims based on similar noncompliance. But the Escobar court also said that required compliance as a prerequisite for payment does not automatically make something material. So in this case, we have CMS, who has not revoked approval for the product, has not declined to reimburse the product, nor has CMS requested reimbursement for the product, which is absolutely within CMS's power to do so.
Does the record spell that out, or we're just to assume that there's nothing in the record that goes one way or the other?
According to the record is silent, and the record has not stated that CMS has made any indication to change its position.
Counselor, I'm a little troubled by what we have set before us here if we adopt what you're asking us to adopt, because it would kind of make the statute have sections that would not be applicable. So for example, there's a section that allows the government to intervene, and when they don't, we can still have this claim. But if you're asking us to interpret the lack of intervention as being preclusive of the claim, it would make that other portion of the False Claims Act not have any purpose. So obviously, when the statute was created for these claims, they envisioned situations in which the government would elect not to intervene, but we would still have a claim going.
Yes, Your Honor, and this doesn't mean to completely wipe out the key, our argument is not to completely wipe out the key TAM provision, but the argument here is that since this materiality standard is so heightened, and because the relator has to establish causation, we run into a problem of the False Claims Act being used to enforce regulatory compliance. And that's what's at issue here, is that what's being alleged is purely a regulatory compliance issue. And that's something that the False Claims Act was never meant to address. And I'd like to point you to the case Ex Rel Petrados versus Genentech out of the Third Circuit in 2017. In that case, relators brought suit alleging that a medical device manufacturer suppressed side effect data that would have affected the government's decision to reimburse the product. In that case, the Third Circuit, applying the demanding Escobar standard, held that the relators failed to state a claim because the FDA, CMS, and the government, through the DOJ, refused to take any action, despite the fact that they were faced with the alleged fraud. And in that case, the court held, quote, where expert agencies and government regulators deem these violations insubstantial, it is not appropriate for a private citizen to enforce this through an FCA claim.
But haven't other circuits disagreed with that position? Allowed claims when the government hasn't decided to intervene and hasn't decided to speak to the issue you're talking about?
Yes, Your Honor. Specifically the Campy Court, which the Court of Appeals below relied very heavily on. But the Campy Court neglected very important public policy concerns. And that's actually something that the First Circuit inaugural court, which we discussed earlier, brought up and criticized the Campy Court for ignoring the public policy concerns that are involved with permitting False Claims Act claims to promote regulatory compliance. And the inaugural court noted that Campy was fundamentally flawed by neglecting the fact that the jury should not be able to overturn the FDA's decisions. Because the FDA and the government knew of this alleged fraud and have chosen not to take action, this means that a relator necessarily fails to establish the direct causal link and the materiality element, which requires showing that the misrepresentation had a significant effect on the decision to pay.
So your argument is that we would be overturning the FDA's decision, but I'm failing to see how the complaint as brought by Ms. Ortega actually is overturning an FDA decision, because the question about the product at issue isn't the one the FDA actually approved.
You're right, Your Honor. And I would say that a better way to say that would be, this permits using the FCA to enforce regulatory compliance and steps on the FDA's toes, whether that's through approval or choosing. I see my time is up.
You can finish your statement.
And for these reasons, Your Honors, we respectfully request this court reverse the judgment of the Court of Appeals below and render the motion to dismiss granted. Thank you.
Good afternoon, Your Honors, Mr. Chief Justice, and may it please the court. My name is Garrett Wolf, and I, along with my co-counsel, Katie Greenspun, will be representing the respondent, Riley Ortega. I will be discussing why the Federal Food, Drug, and Cosmetic Act does not preempt Transylvania's immunity statute, and my co-counsel will be discussing why fraud on the FDA is a viable basis for an FCA claim. Your Honors, this case centers around one core principle to our constitutional structure, the idea of state sovereignty. Respondents respectfully request this court affirm the decision of the 17th Circuit Court of Appeals on the basis that the immunity exceptions provided by Transylvania statutes are not preempted by the Federal Food, Drug, and Cosmetic Act for the following three reasons. First, the presumption against preemption is directly applicable here, because the state of Transylvania is exercising its historic police powers to regulate the health and safety of medical device consumers. Second, neither respondent's claims nor Transylvania's immunity statutes differ from the requirements imposed by federal regulations. And finally, petitioner's arguments, if accepted, would create an absurd situation where the corporation would enjoy immunity from products liability actions within the state of Transylvania. Turning to my first point. Your Honors, this court has long recognized the traditional role that states play in regulating and promoting the lives, health, quiet, and comfort of their citizens. And it's indeed the presumption against preemption that works to protect a state's sovereign interest to regulate these very matters. In Medtronic versus Lohr, this court reaffirmed the proposition that a state's historic police powers are not to be superseded by a federal act unless that was the clear and manifest purpose by Congress in doing so. Now, pursuant to their historic police powers, the state of Transylvania enacted a products liability statute by codifying their products liability law into their state code. As page 8 of the record reflects, Transylvania did this with the goal of encouraging medical device manufacturers to promote the health and safety of Transylvania's residents.
Would there be any limit on the state in enacting its tort law with respect to devices that might also be regulated by the FCA? Or is it simply because it's part of state tort law, we're free to go as far as we'd like into the territory governed by the FDA?
Yes, Your Honor. Under Section 337A of the FDCA, there would be a limit to these products liability laws. States cannot impose remedies that add to or differ from federal requirements. They must explicitly parallel federal regulations, and that's precisely what we have in this case. As page 8 of the record shows, Transylvania enacted their products liability statute and disclaimed liability for medical device manufacturers, so long as they are meeting the FDA's approval requirements laid out under the Federal Food, Drug, and Cosmetic Act. In effect, the state of Transylvania is directly regulating and restricting when injured consumers can recover under their state's products liability law. This is a matter of traditional state regulation, as recognized in this court in Medtronic versus Lohr. Now, petitioners' attempts to mischaracterize the relationship at issue in this case as being solely between the Food and Drug Administration and petitioners themselves is not only misguided, it is a gross infringement upon the state of Transylvania's sovereignty to regulate matters of health and safety. Of course, petitioners make this assertion in order to analogize this case to this court's holding in Buckman versus Plaintiffs' Legal Committee. However, Your Honors, there are two key distinctions between this case and this court's holding in Buckman. First, in Buckman, the plaintiffs were asserting claims based solely upon a defendant's violations of the medical device amendments to the Federal Food, Drug, and Cosmetic Act. Those were the only claims asserted in that case. Second, there were no state common law claims asserted, nor any state products liability law anywhere in the course of the litigation. This court held that the presumption against preemption was inapplicable because the relationship there was federal in character, meaning that it originated from, was governed by, and terminated according to federal law. And your honors,
But is this just a case of, well, if we artfully plead our case, we can get around that problematic preemption issue. So that seems to me you're putting a premium on exactly how you word your pleading rather than the real substance. How do you respond to this, however you dress up the action and whatever words you use? This is really a challenge to FDA regulatory authority.
your honor, respondents would point out that so long as this court has held in time and time again in Rival versus Medtronic and Buckman versus Plaintiffs Legal Committee, that is so long as a state is not imposing requirements in addition to or different from those imposed by federal law, plaintiffs' claims may proceed. It merely provides an incentive for manufacturers to comply with federal regulations by explicitly paralleling those regulations, not adding any kind of additional responsibilities for a manufacturer to have to comply with 50 different state tort regimes. This is precisely why the presumption against preemption doctrine is implicated in this case. Respondents would agree that if the sole relationship at issue in this case were between the Food and Drug Administration and petitioners themselves, the presumption would not apply, and respondents' claims may very well be preempted by federal law. However, to be clear, that is not what we have in this case. The relationship at issue in this case is between the federal Food, Drug, and Cosmetic Act and the state of Transylvania's immunity statute. This relationship is
Counselor,
not.
would your argument change if your claim itself rested on a compliance with the FDA? For example, if you'd had a negligence per se claim here, using the violation of the FDA rules and regulations as a piece of your prima facie elements?
Yes, Your Honor. If that were the case, then respondents' claims would be impliedly preempted by federal law, as they would be in violation of Section 337A of the FDCA, which states that all suits to enforce the FDCA shall be by and in the name of the United States itself. And that's precisely why Transylvania's statute is so critical here, because it provides a means for injured consumers to recover and remedy the violations they suffered as a result of a defective product that's been on the market. And this brings me to my second point, Your Honors. Neither respondents' claims nor Transylvania's immunity statute interfere with the operation of federal law here. Both petitioners and the 17th Circuit rely on the 6th Circuit's reasoning in Garcia versus White-Ayers to find that the immunity statute imposed by Transylvania interferes with the FDA's regulatory abilities. However, Your Honors, the 6th Circuit overextends this court's precedent in Buckman versus Plaintiffs Legal Committee from claims that originate based solely on a defendant's violation of federal law to those which involve inter alia fraud against the Food and Drug Administration. Petitioners and the 17th Circuit also misconstrue the state of Transylvania's immunity statute and this court's precedent with regards to federal preemption. Under Riegel versus Medtronic, this court held that a state may impose additional damages remedies for claims based upon violations of the FDCA, so long as those requirements are not in addition to or different from those imposed by federal law.
Counselor, damages and adjustments is very different than what's at stake in this case, where you're asking essentially a fact finder to determine whether or not the petitioner is immune based on the fraud to the FDA or the compliance with it.
Your Honor, per page 6 of the record, Riley is alleging that Vendology breached its duties of care, traditional common law duties of care, which are owed by a manufacturer to their consumer. She does so in the manner prescribed by Transylvania's legislature in order to rebut this presumption of immunity. However, these claims are rooted in traditional common law duties of care, and merely requiring a state court to consider or a jury to consider fraud against the FDA does not create the situations that petitioner voices. The ultimate judgment will be a determination of whether or not the manufacturer has breached its duty of care to the consumer. That is what juries are going to be weighing in on, and that's what judges will be ruling.
But essentially, when we're dealing with the defense, the immunity, wouldn't we have to directly address the compliance with the FDA and the FDA?
Your Honor, per page 8 of the record, Transylvania statute requires under subsection A that a manufacturer is granted immunity so long as they are meeting FDA approval requirements. There are two critical immunity exceptions to this statute. Subsection B, which requires a plaintiff to prove that a manufacturer withheld or misrepresented information that was required to be submitted to the FDA in order for the FDA to make a determination of whether or not the product should have been approved, and that the FDA would not have approved the device or would have withheld approval had they known about this information. Under subsection B, a plaintiff is required to prove that a manufacturer failed to notify consumers about the dangers or risks associated with the medical device in question, as required by the Food and Drug Administration. The state of Transylvania's products liability law, to be clear, does not add any kind of additional or different requirements than those imposed by the Federal Food, Drug, and Cosmetic Act. It merely incentivizes manufacturers to comply with those federal regulations. It also relies on this court's reasoning in Rigel versus Medtronic and Buckman versus Plaintiffs' Legal Committee, which, when read literally, create a narrow pathway for a plaintiff's common law claims to follow. They can be suing for conduct based on a violation of the Federal Food, Drug, and Cosmetic Act, but not solely because of a defendant's violation of the FDCA. Again, as page 6 of the record shows, that is precisely what Riley's claims do here. Riley alleges that Menology breached its duty of good care and faith in violation of Transylvania's products liability statute. To take advantage of subsection A, she alleges that Menology failed to notify the FDA of the changes in its device after it was approved. And to take advantage of subsection C, Riley alleges that the petitioner failed to notify consumers about the presence of PPER foam in the product. These claims.
Is this the nature of your claim, in order to progress test or finish a case and into the aspect of the statute? Wouldn't that really ask us as a court to interfere with the FDA's ability to regulate and police the conduct of regulating manufacturers of products?
No, Your Honor. The claims as they stand now require state courts to make a determination on whether or not there has been a breach of traditional common law duties of care.
And I understand the argument with respect to the Prima facie case, but if you can more directly address the immunity issue, which is where I find this much more problematic.
Your Honor, respondent is required to plead that a manufacturer intentionally withheld or misrepresented to the Food and Drug Administration information that was required to be submitted under the FDCA. And she does this according to the manner prescribed by Transylvania's legislature. Regardless of whether or not a state court needs to make a determination as to whether there has been a violation of federal requirements, the additional claims that respondent is asserting are common law duties of care. There's a dual purpose to respondent's claims here. She is alleging that petitioner violated the Federal Food, Drug, and Cosmetic Act. She does so in the manner prescribed by Transylvania statute to bring a breach of traditional common law duties of care, long recognized in courts of law prior to the enactment of the Federal Food, Drug, and Cosmetic Act, and even prior to the existence of the Food and Drug Administration themselves. This is precisely why the state of Transylvania's immunity statute survives federal preemption here, because it merely follows this court's precedent in Rigel and Buckman and provides a method for injured consumers to recover under their state's products liability law. I'd like to turn to my third and final point. Your Honors, petitioner's arguments, if accepted, would create an absurd situation where the corporation would enjoy immunity from products liability actions in the state of Transylvania. As page 3 of the record reflects, Riley is a United States veteran who is seeking to alleviate the symptoms that she suffered from as resulting of years of service in the military, including sleep apnea and PTSD. Page 5 of the record shows that her medical provider recommended that she utilize petitioner's Sleepternity device, as it was specifically designed and tailored for consumers who were suffering from her similar injuries. Petitioner's broad preemption argument would leave no judicial remedy for Riley to remedy her injuries that she resulted from petitioner's device. As page 36 of the record reflects, this is precisely the concerns that the 17th Circuit had and what led them to uphold subsection A of Transylvania's immunity statute. But Your Honors, this only further bolsters upholding subsections B and C as well, because in effect, Petitioner's argument here would gut traditional common law duties of care. Your Honors, in the face of congressional silence as to whether or not the FDCA preempts traditional common law duties of care, this court should not misconstrue the FDCA to preempt those types of claims unless Congress unequivocally and explicitly states otherwise.
So you would say that we shouldn't have implied preemption?
Yes, Your Honor, neither implied or express preemption applies in this case.
No, I'm saying your argument is that unless it's, I believe your argument was unless it's expressed, we shouldn't have it. So are you arguing that there's no implied preemption possibility?
Your Honor, Congress needs to state unequivocally. They have with regards to express preemption in section 337A of the statute. Your Honor, I see that my time has expired. Thank you.
Good finishing statement.
They have stated in 337A in regards to express preemption, Congress has not spoken to the issue of whether traditional common law duties are preempted here. For these and the foregoing reasons, we'd ask this court to affirm the decision of the 17th Circuit. Thank you.
Good afternoon, Your Honors, Mr. Chief Justice, may it please the court. My name is Katie Greenspan, and I too represent the respondent, Riley Ortega. I will be discussing the issue of fraud on the FDA as a viable basis for liability under the False Claims Act. Today, this court will hear about the case of a young woman injured by a corporation that knowingly used unsafe, FDA unapproved materials and engaged in fraudulent misrepresentations to the FDA and the Centers for Medicare and Medicaid Services. Respondents respectfully ask this court to affirm the holding of the 17th Circuit Court of Appeals for the following 3 reasons. First, Menology knowingly misled the FDA when it failed to update the agency as to its device change, rendering subsequent claims for payment to CMS false. Second, Menology's fraudulent misrepresentations were material to the government's payment decisions. And third, Menology's fraudulent conduct meets the causation standard as a matter of proof, not grounds for dismissal. Turning to my first point, Menology knowingly misled the FDA when it failed to update the agency as to its change to paper phone. A principle in tort law applicable here to FCA claims holds that if the defendant does speak, they must disclose enough to prevent their words from being misleading. Menology did not do this. Menology's words were misleading for the very fact that it omitted notice of the change to paper phone. There is a statute within the Federal Food, Drug, and Cosmetics Act, Statute 510K, which notes that when a manufacturer makes a significant change to its device, affecting the safety and efficacy of the device, this change must be reported to the FDA under the 510K pre-market clearance approval process. The FDA has created a flowchart to inform a manufacturer when a specific change warrants reporting. The flowchart asks 4 questions. The first question asks whether there was a change to material type or composition, and the answer to this is yes. As page 4 of the record supports, Menology changed from silicone to paper foam. The second question asks whether this material directly or indirectly contacts bodily tissues or fluids. The answer to that is also yes. As page 3 of the record indicates, the device at issue here, Sleepternity, is a CPAP machine, which is worn as a mask. The foam within a CPAP machine must break down for it to function properly. However, when silicone breaks down, it does not emit volatile organic compounds, which paper foam does emit. And one of those volatile organic compounds is isocyanates, which Riley, in this case, suffered severe allergies to and has chronically inflamed lungs now, as supported by page 5 of the record.
Counselor, you're talking about all the different attributes of what kind of foam insulation we could use in these machines, and it just raises for me the concern here about whether or not these kind of claims are really intended to do what you're asking, which is really to second guess the FDA's judgment on what should be sufficiently safe in order to be approved. Aren't False Claims Acts really limited to protecting the government fraudulent claims from paying out on those?
Yes, Your Honor, that is the purpose of the False Claims Act, but the government relies on FDA approval first as a proxy for safety and efficacy. This is not to second guess the FDA's approval process, but to reaffirm what is important to it in its initial approval. And the FDA was deprived of this ability to make an initial fully informed decision.
Couldn't the FDA join in this action right now if it so chooses?
Your Honor, this is a qui tam provision on behalf of the government in which Riley is representing the harm that the government suffered as based upon FDA approval. This is an action against the corporation, not concerning FDA as a party, but fraud on the FDA, in which the FDA has already indicated a voluntary recall, which the court of Fifth Circuit held in Hughes versus Boston Scientific. A voluntary recall can be seen as an action on part of the FDA. Briefly returning to the flow chart, which indicates when a change must be reported. The third question asks whether there was a risk assessment indicating new or increased biocompatibility concerns. The answer to that is also yes. As page 4 of the record indicates, Philips, another medical device manufacturer, had recalled all of its CPAP machines incorporating PEEPR foam in 2021 due to the associated health risks, which the FDA issued a public warning regarding the Philips recall and PEEPR foam. It knew of these associated health risks due to laboratory testing and reports of former consumers. The final question asks whether this manufacturer had already used the same material in a similarly legally marketed device. The answer to that is no. Mednology has never received FDA approval for PEEPR foam device. The results from this flowchart were clear. A new 510K was required. Mednology did not file one. Even if petitioner notes this was not a major substantial change warranting a new 510K and was indeed a minor change, as on a technical level, silicone and PEEPR foam could be interchangeable, the manufacturer would still find themselves in a bind regarding the FDA's requirement that a manufacturer, in the face of public health risks, add a contraindication to its warning label.
If this is such a grave concern, why isn't the government intervening?
Your Honor, the government has decided it adequate Riley's representation of its issue. That is the sole purpose of a qui tam provision in which Riley may represent the interests of the government. In this case, regarding the fourth question,
Can you address the petitioner's argument, though, that the failure for the government to intervene is suggestive of that you don't have a claim that should allow you to proceed on?
Your Honor, the petitioner has characterized the government's payment decisions in a flawed light. In first, the petitioner characterizes CMS as approving a device, but it is the FDA who approves of a device and CMS who reimburses. CMS reimburses based on FDA approval as a proxy for safety and efficacy. Petitioner has also noted that there are instances in which the government may choose to reimburse for a device that does not have the FDA seal of approval. However, within CMS's policy manual, it notes that instances without FDA approval are isolated to clinical research trials regarding investigational drugs, including Schedule I drugs of psychedelics or marijuana. That is clearly not the issue here. This regards a Class 3 medical device, as noted by page 4 of the record, for which CMS requires FDA approval.
Has the FDA withdrawn its approval?
Your Honor.
So what is it, sleep turn-in device?
No, Your Honor, the FDA has not rescinded approval as noted by page 7 of the record. However, as both Campy versus Gilead Sciences in the 9th Circuit held and Hughes versus Boston Scientific in the 5th Circuit held, there may be a myriad of reasons for the FDA not initiating action. As Hughes versus Boston Scientific ruled, FDA inaction there's no case authority holding that FDA inaction is a necessary prerequisite condition for a parallel suit. This FDA inaction is not validating of a device or dismissing potential fraud. And as a former FDA official noted as expert testimony for Hughes, the FDA usually relies on a voluntary recall to correct for reporting violations so as to not have to initiate its own time-consuming and costly measures.
And that's what happened here. There was an investigation, right? And pending that investigation, Mednology withdrew voluntarily, right? Am I right on that?
Yes, Your Honor, you are correct on that. And petitioner did cite to Nargo versus DuPois Orthopedics, a First Circuit case, holding that the FDA is equipped with a robust set of regulatory tools.
It seems to me that the argument that you're making now is exactly the problem that's faced. The FDA makes its determination as to how to deal with this situation, okay? For whatever reason. But now we want another branch of the government to substitute its judgment for what the FDA has decided. And we're going to do that under the guise of the False Claims Act. So all regulatory noncompliance becomes the basis for a False Claims Act. That seems problematic.
Your Honor, as noted by the former FDA official in Hughes versus Boston Scientific, a voluntary recall is one of the actions that the FDA may utilize to correct their device. So it is not conceding that the FDA has not acted, as in this case, it may have acted. But the core focus of the FDA claim is on whether the government has been defrauded. And that regards the causal chain, which is point 3 of my argument, in that Mednology's fraudulent conduct may be linked to harm suffered by the government. As page 4 of the record indicates, CMS did pay claims for Sleepternity, but it reimbursed for a modified version. Even if the FDA did not rescind its approval, that rescindance or lack of a rescindance was based initially on a device that was not reported officially to the FDA. It was not fully informed of this. And CMS was in turn deprived of the right to base its eligibility criteria of reasonableness and necessity of a device for market on the proper eligibility criteria. Turning briefly to my second point, Mednology's fraudulent conduct was material to the government's payment decisions. This court held in Universal Health Services versus Escobar that for a misstatement to be material, it must be found that it would have impacted the government's payment decision. That is not relying on hypotheticals, but highlighting the importance of withheld information and the way it may impact the government. As already noted in response to your Honor's questions, the First Circuit holds in D'Agostino versus EV3 that a relator may not be able to meet the materiality threshold without citing to official FDA action. This is not what Hughes versus Boston Scientific held, nor is it what Escobar meant by its rigorous pleading standard. Escobar does not require proof of a guaranteed different outcome. As again, this is the motion to dismiss level, not requiring proof, but enough facts in the record to support Riley's claims as plausible, not merely possible. But moreover, Escobar only requires showing that there was a potential to influence the government's payment decision, which has indeed been demonstrated in this case. CMS based its reimbursement decisions on the assumption of full compliance with FDA regulations.
So what allegations of materiality do you believe meet the plausibility standard?
Your Honor, that turns to the third point, the causal chain. There is a clear causal chain linking Mednology's conduct to harm suffered by the government. As page 4 of the record indicates, Philips recalled its CPAP machine. It issued a statement, as page 4 of the record supports, noting that this material was not safe for human use, and it would make every reasonable effort to switch to silicone, which it endorsed as the safer alternative. As page 5 of the record indicates, Jim, Riley's brother, who worked for an assembly line manager for Mednology at the time, knew that Mednology said it used silicone solely to procure pre-market approval, but then switched to paper foam for cost-saving measures without reporting this to the FDA. As page 4 of the record indicates, Riley went to her physician complaining of sleep apnea and insomnia symptoms, which her physician prescribed her Sleepternity to address these issues. Both Riley and her physician knew that she was allergic to isocyanates, but because Sleepternity's warning label contained no mention of paper foam, neither knew her allergy would be at issue. CMS then reimbursed for this device, as noted on page 4 of the record, using codes associated with a class 3 medical device incorporating silicone, not paper foam. Like a row of dominoes in which the tipping of the first leads to the inevitable collapse of the rest, Mednology's initial fraudulent conduct, Concealing this material change from the FDA tainted all future payment claims, bringing the FDA, CMS, and Riley down along the way. Again, D'Agostino versus EV3 attempts to note that the relator may not be able to prove that the FDA would not have granted approval but for the defendant's fraudulent conduct. But that concern is just that, a practical problem of proof. And this is at the motion to dismiss level, meaning that Riley would only present enough facts to support your claims as plausible, not merely possible. There is a clear material of facts and causal chain in this issue. In matters concerning public health, Menology should have known it better to ask for permission rather than forgiveness. For FDA approval does not absolve a manufacturer of ensuring ongoing safety concerns, and in concealing this information, Menology violated its post-approval safety standards and undermined the public health framework intended to prevent harm to the government and consumers alike. For the foregoing reasons, respondents respectfully ask this court to affirm the holding of the 17th Circuit Court of Appeals and allow Riley's claims to proceed. Thank you.
Your Honor, may it please the court. 2 brief points on rebuttal. First, Justice DeSanta, you insightfully brought up the fact that respondent effectively relies on artful drafting of the statute. But as Justice Breyer reminds us in Egelhoff v. Egelhoff, it is the job of preemption analysis to look to the technical detail of the law, not merely wistful flourishes of words. And it is exactly because of this that the technical detail of these statutes is revealing, because at the end of the day, they still present as a threshold question, or as this court described in Buckman, a critical element, the policing of a relationship between the regulated party and the FDA. Though respondent did state that subsection B talks about misleading the FDA, he stopped short of reciting the full provision, which requires the fact finder to determine that the FDA would have made a different decision. This is the kind of interbranch meddling that the court was concerned about, and it's exactly why these provisions themselves are preempted. Second, on the False Claims Act, respondent makes a great to-do of a flowchart provided by the FDA. However, this is emblematic of exactly the caution that this court spoke to in Escobar, that the role of the False Claims Act is not to police regulatory compliance. The point at which this court is cycling through FDA guidance documents to determine whether or not there's been a False Claims Act violation is the point at which it is running afoul of its own precedent. And for that reason, a fraud on the FDA theory is far too myopic to support a False Claims Act violation. And for that reason, we ask that you reverse the holding of the 17th Circuit Court of Appeals.